Thank you. Professor Guy Mundlak of Tel Aviv University is a joint appointment with the Faculty of Law and the Faculty of the Social Sciences, and his work deals with the impact of law on labor markets and the welfare state. Guy is my department
head. Okay, thanks, CC. And since I have to be spontaneous about this presentation, then I'll do some on my own preliminary remarks, and I'll think about what I want to say in the meanwhile. First of all, I was thinking about Johnny Mitchell. To paraphrase Johnny Mitchell, they paved paradise and put all the lawyers in one session. So, that makes sense. And second, I thought that it's very courageous to show a picture of a pig at the beginning of a presentation in Israel. Nice job. And a pink pig. Okay. It's a great research project. I have some thoughts about it. You start with what is the place of the Supreme Court, and I wonder what is the meaning of the word place. Place in what context? Do you mean what is the impact of the Supreme Court? How does it interact with the other branches of government? How does it interact with private players? To what extent do private players view the Supreme Court as a strategic place in which they can come and actually affect policy? When would they want to go to the Supreme Court? When would they prefer to go to other venues? So some of these questions may not actually be questions that you would want to look at cases, and perhaps you would want to look at the plaintiffs who go to the court. So I think I would need a better idea of what is it that you're looking for when you're talking about the Supreme Court as a place, as an agent, as a place, as a what. Now, the second thing, you offer to use here two methodologies, a quantitative study and a qualitative study. And with regarding to the quantitative study, I wonder, is this really a field for quantitative study? I mean, it's interesting to show in the numbers. I mean, they're striking. But it's quite obvious. Now, once we move beyond the aggregate numbers and start looking at what kind of these cases, jury metrics is a fancy thing, but sometimes I think it gives us limited results. And I think that a lot of the cases that come in the context of pensions to the Supreme Court, these are serious policy issues. I mean, I would be very hesitant in terms of just aggregating. So you brought the Ilan case from last month. 3 weeks before, I think, was the case where the old pension funds, there was a decision to pull together the management of all the old pension funds. The pension fund, which was at the best state, petitioned the Supreme Court, arguing that they don't want them to pull together the pension funds because now all the considerations will be the considerations of the funds that are not faring well, and therefore they will be a burden on the prosperous fund. And the court ruled against the argument that the management fees that the funds take are too high and that the state is actually approving the high level of management fees. And I think, Avia, you will correct me on this, but I think the management fees has nothing to do with how much it costs to manage. I mean, the management costs are way, way lower than the management fees. The management fees are about balancing the budget of the pension funds. And the court doesn't even refer to these kind of arguments. It just says, well, the state has a broad leeway, and the state can do whatever they want. And I'll work on the argumentation of the state in a second, of the court in a second. So, if you do a quantitative analysis, you'll have, I have one case where the court accepted the petition, in the other case the court rejected the petition, and once you start overlooking the detail, the nuance, and the mode of justification, then I think you're going to lose more than you're going to gain. So the striking figures that you bring show a process of juridification in Israel where everything is brought to court. They show a process where the pension system has become much more complex and the agents are much more diverse, and that's fine. it's a good thing for the introduction. I would suggest to leave it at that. The qualitative approach, I think, is way more interesting, and I think both what you did with Bar Ilan and both what you did with the discrimination case with the widowers, you know, it's an interesting way to build an argument. And here, you're actually starting to look at the bits and pieces of what the court is doing. Now, at the end, you suggest a classification by topics. I think that resonates better with the quantitative analysis, which I suggest to do away with. I would suggest to you to do a classification of themes, which resonates better with the qualitative analysis that you suggest. And here I would like to emphasize a few things, I think that follow some of what you said and perhaps add a bit. First of all, one thing that I do not understand is why are you doing this about the Supreme Court? And you're putting aside the National Labor Court. The National Labor Court is a significant agent in this story. And for the guests, there is basically the National Labor Court has separate jurisdiction. Sometimes the Supreme Court and the National Labor Court will have overlapping jurisdictions. If the Supreme Court doesn't want to deal with the issue, it will relegate it to the National Labor Court. So, for example, now we have pending a very important case where a number of NGOs petitioned against the 2008 mandatory pension. The mandatory pension starts at the age of 20 for women, 21 for men, and therefore the argument was that this puts aside Arabs, people with disabilities, and people who are not serving in the military for other reasons, who are starting to work at the age of 18, and there is no reason to exclude them from pension coverage as part of the mandatory pension. This was brought to the Supreme Court. The Supreme Court relegated it to the National Labor Court. I think it's a serious question. I think it should be part of your study as well. And clearly an interesting study would be, is there a different twist to litigation in the Labor Court or litigation in the Supreme Court, and the differences in the way the judges view? The traditional story says that the National Labor Court is more social-oriented, is more activist, and the Supreme Court lesser so. I don't buy that dichotomy, but that's me. But anyway, I think this is a fertile ground to check that assumption as well. You have 3 tiers of pension. Do you want to focus only on the second and the third tier of pension, which currently blur, or you also want to look into the basic social security kind of old age pension, which I think raises somewhat similar concerns, somewhat very distinct concerns. A third thing, you have here a whole lot of agents, and I think it's really important to figure out how the agents interplay in the strategic field of the court. You have the state, which is currently, I think, is speaking pretty much in one voice with some variations, but you have the funds which speak in many voices, and you have different kind of funds. You have the old funds, you have the new funds, you have prosperous funds, you have failing funds, and you have the people who are insured in the funds. And here you have a very heterogeneous group. And I think it's a very interesting question to see how the court deals with this diversity. If you're going to do a quantitative study and you're going to start coding, saying funds is 1, people who are insured is number 2, and I'm going to start saying who submitted the petition, a number 1 or a number 2, I think you're going to miss out a significant piece of the interesting story. And it's not only that it won't be deep enough, I think it will be misleading. If you go for the qualitative thing, I would look at questions of justification. And for example, in the case of the pooling together of the old pension, of the management of the old pension funds, it's interesting to look at the way the court justifies its position. The court can say, I don't want to intervene in what the state decides. That's a matter of separation of powers. The court can say a different thing, and that's, I think, what the court said in that case, that pension funds are a space of solidarity, and therefore the pension funds and the state are responsible that the pension funds will be viable and that they will be able to pay everyone. And therefore they can do whatever they find necessary and whatever they deem necessary in order to ensure the strength of the pension fund. And that's the way the court is going. It's not saying I'm not intervening. It's not a separation of branches argument. It's an argument about the care for the people who are insured in the pension funds. And I think that there is a strategic choice that the court is making in the way that it's framing its argumentation. And this is a qualitative thing that you need to do, not only read the lines, all of them, but actually read between the lines and think about the alternative ways the court could have made the same argument. My hypothesis here would be that the courts do not want to intervene in the idea of solidarity. They generally will not want to act in favor of one group at the price of another group, and they will leave very broad discretion for the funds and for the state to maneuver between the rights of different categories. And this is very similar to the approach that they used to take to collective bargaining. Whatever is collectively bargained, there is an assumption of autonomy, and the court will not intervene in the quid pro quo and the trade-offs that the partners to the collective bargaining are doing. The only difference is this is no longer a collective bargaining. This is a much more sophisticated play now. It's more political, I think, and it's more complex economically. And I think that leaving the autonomy to the parties, to the state, and to the funds to manage the funds as they see fit, there are a few reasons why the court would prefer that option and not to go deeply into the idea of intervening in the way that the pension system is running. I think the Ilan case is different. It's qualitatively different. It's about who is going to represent the retirees. They don't view this as a pension case. They view this as a collective bargaining case, which is interesting that they're willing to deal with a collective bargaining case in the Supreme Court as well. But I think it's a different question, and I think you rightly cluster it together with it as part of our discussion on pension, but for them it's a different case. I think your focus on the questions of the areas of law is also right. There is administrative law, there is private law, and there is constitutional law. In terms of constitutional law, which I find the most fascinating in this context, anything that has to do with social law and the right to social security and the right to dignified living and the right to dignity and whatever you want to say that, the court is okay with rhetoric. It does totally nothing. And in this sense, I think I don't expect to find anything in the context of pension that is being delivered explicitly in terms of social and economic rights. The interesting thing is, what is the court willing to do in terms of property rights? Because property rights resonate better with the neoliberal system that is being developed in Israel. And I think that so far the courts have been reluctant to acknowledge strong property rights of insurees in the pension funds. And you see that both in the social security cases and both in the pension cases. Sorry?
Also contract. So contract will go both ways.
And contracts, I think there would be a bit more potential if it's dealt as part of contract law and not as part of the constitutional law, and the freedom to contract is derived from the autonomy, is derived from whatever. So I mean, I'm finishing. So as long as we're doing constitutional law, we're going to see a very weak aspect here in terms of administrative law. The courts are going to give a very, very broad leeway. That would be my hypothesis, to the state in whatever it does. And the interesting area is to see whether through private law mechanisms of contract law and property law, not as a constitutional right, but through the nitty-gritty private law, which Neta yesterday said that NGOs don't know how to use, and a lot of agents still haven't learned how to use these kind of instruments as instruments for mobilizing social change. I think this will be the interesting place to see whether there is some kind of development and whether the courts are willing to do with these kind of instruments something of significance.
Thank you, Guy. Questions? Lila, first. And then who else raised?
Okay. Two comments. about the research seems very interesting. The first comment relates to the end of your presentation. If the court might say, this is something that I am not qualified of. I think that the interesting thing is that the court does not tend to say so, as although when I read the court's ruling, I see a lot of times that they don't understand anything, including in the Fidelman case when they ruled that there is a discrimination when when we give different benefits to widows when they're men and women. And this is without noticing that the whole system of the new pension funds from 1995 is if men and women work the same years and have the same money in the funds, they will receive benefits that are unequal because of actuaric, life expectancy that is different. So the whole system is unequal. It depends, of course, how we, what we think is equal or unequal. And another thing about this is that when Steve Adler retired a few months ago from the National Labor Court, he was interviewed, and he said in the interview that one thing he maybe regrets is that he's not sure he understood everything when he ruled about pensions. So that's his words. So this is the first comment. The second comment about the methodology. I wonder if you just put the word pension in the search, you will really get cases that are about pension, because you can get many cases, and if you really want to look only about cases of the Supreme Court as a court of justice, so there aren't many cases, especially in the categories that you mentioned. There are 2, 3, maybe 5 cases in each category. Maybe we can learn other things by the word pension, but it's not this.
I just wanted to ask, maybe Guy, maybe you, about, you mentioned justifications, and it's important to, so thinking about Vinny's presentation yesterday, and what you said, that civil society actors don't know how to use the court system. I wonder if it's also important to look at how the sides, the plaintiffs and the, whatever the other side's name, the respondents' justifications are, and how they evolve over time, and whether there is an interaction between the rhetoric that the court uses and the way maybe it socializes civil society actors or vice versa. Eli doesn't allow me to talk anymore.
Just very briefly, because I have very little comments after Guy spoke. But 2 things. Actually, one, just follow up on Lilach's. I as well thought that, I'm not sure actually, I never looked at it this way, but perhaps some of the interesting issues that come to the Supreme Court are actually civil appeals with all the privatization of the funds. I'm not sure how it goes, but if an actual actuarial or whatever interesting, perhaps even policy decision of a suit against a claim against a pension fund is brought by an individual person, does it go through the labor court and then to the High Court of Justice, or can it go directly through the courts? I'm not sure. Not to mention issues. Who knew about the Miftachim case before it came to court? But we can imagine cases between funds that will come to the courts, and so I think the High Court of Justice is limited. And on top of that, of course, I also agree that you should look into the National Labor Court. But more importantly, I think there was a conference here last week, and I'm kind of following up on what I said there. What I said there with regard to social rights is the courts are much more prone to look into cases and to intervene in cases that involve discrete individuals that have names, Fidelman, etc., then to talk about social groups. This kind of follows up also on what Guy said. So it's not surprising what's surprising is perhaps the ignorance that they didn't know how to do. But even then, they thought at least they knew that, you know, you have a man and a woman, the man gets like less than a woman. They thought they understood that. It's a clear case of injustice, and that's it. When it comes to more complex groups, the courts are much more hesitant to intervene. From a very, very different, very briefly example, the court can say, and it did say, a particular disabled individual in a wheelchair that can't access his classroom, the school should provide access to a lift that will allow him to reach his classroom safely, along with all his friends. But other cases that involve, you know, the whole cohort of disabled individuals in schools, of course, that was thrown out of court. So the court is much, much more reluctant to deal with a magnitude of individuals that come to court as a group, more costly. You know, there are a lot of explanations than when we're talking about concrete individuals. I think that should be, and it could be exactly the same. We could talk about social integration here and there, but if it's one individual, they'll say yes, and if it's a group of them, they'll say no.
Thank you. Need to keep it brief.
From my point of view, the interesting side is the side of administrative law, because the reform is so patched up from the point of administrative law, and there was a special law that was enacted in the reform to give the controller of insurance special rights, but it's not the right way to do it administratively. The right way to do it is to have a pension law that will state who has the responsibility, will have a reason why it is enacted, etc., etc. This is one point. The other point, also about administrative law, is the point of transparency. I think that the Supreme Court could be called upon to increase the transparency. And the transparency is non-existent there. You don't know what happens. You do not get the information. You don't get the actuarial balances. You don't know anything. You don't know whether your rights are okay or not. And I think, and the third thing that was talked about is the equity in the reform, because there is no transparency, one cannot know whether he is getting more or less. And it is true, as you said, that the court decided not to go into that, but I think that it is still an issue which should be on the table. Thank you.
Am I allowed to comment as a timekeeper? Just about the Ilan case, what I found unique about the Ilan case was not only that labor unions represent retirees, but that the representative of the retirees, labor union, are allowed only to benefit the retirees. They're not permitted to harm in any way, shape, or form. And I think that is also unique, knowing the history of labor unions and such. Do you have any further comments? One or the other? No? So, yes? Go ahead.
The advantage of this kind of presentation is I can say that I want to thank you for your comments. Next year I hope to show the actual results. But from my side I really appreciate your really excellent and thoughtful comments, and I will try to do my best to incorporate them.
Just really quickly to Sandra, in terms of one strategy is to look at what the court is saying, another strategy is to look at the process where the civil society or the private firms bring up the cases to the court, the court decides, and then you want to see how the court impacts the field again, and then you look at it as some kind of a cycle. I think both strategies are good. I find personally the second more interesting, but I think that actually looking at the court cases is a viable strategy in itself in terms of figuring out what the court does. But it's clearly you do want to think about it as part of a legal process where the court is only one episode in a much lengthier horizon. And Avia, it's really interesting. One way to go about this is through substantive law. This is discriminatory, this is wrong, this is outside of the limitations of what's reasonable. Another way to approach these kind of things in court is what's called process-based law. We want the state to give a better account of what it's doing. We want the state to explain. We want the public to be better informed. And I think that the interesting thing, I am very much in favor of process-based law as a way to bypass some of the substantive questions. As long as you're honest and as long as everyone knows what you're doing, then, then we can leave more to the political process. And it's very interesting that the Supreme Court has been very weak in terms of inducing more transparency, a better account on behalf of the state of what are its strategies. And I'm saying this not in the pension context, but in other contexts. Even as I'll finish with that, the most striking example was the several attempts to bring to the court the idea of the Omnibus legislation that we have every year with the budget, in where the state used to change, to make all the economic reforms and tie them to the budget. Either you pass the reforms on a take-it-or-leave-it basis, or the government fails. Even then, the Supreme Court was not willing to come and say there is something fundamentally flawed in this process. Serious economic reforms should go in the mainstream and not through the back door. And so I think that there is much, at the normative level, I think that the process-based reforms... In my sense, everything is political. Because then they say about about what we call political reforms, they say that's not political, that's professional. So let's do away with the distinction.
Thank you.